Hello again, everyone. Welcome to Washington Gun Law TV. I'm Washington Gun Law President William Kirk. Thanks for joining us. Oregon. It's been a while since we've had a chance to talk. Now, we got to spend a lot of time together last year, November and December, as you guys passed Ballot Measure 114, which at the time I said was absolutely the worst piece of gun control legislation I'd ever read, and I stand by that for the most part. And then we got to follow all the trials and tribulations as there was lawsuit after lawsuit trying to stop the insanity from happening in Oregon. But then we had a judge in Harney County stop the insanity, Judge Ratio down there in Harney County, and basically put the entire law on pause. And despite the fact that the state of Oregon went back on not once but two occasions to ask the Oregon State Supreme Court to pick the fight for them, they were denied. So that kind of put everything on the back burner, and then along came the pistol brace rule and the bloodbath of a legislative session that we're having here in Washington, and we haven't had a chance to talk in a while. But guess what? We have some more stuff to talk about, and that oftentimes is not good news when you're appearing on Washington Gun Law. But this is important stuff, and the folks in Oregon need to be aware of it. So today, let's spend a few minutes and talk about when your state legislature believes two wrongs will make it right. Okay, so the issue we are talking about today is the wonderful state of Oregon, in particular Oregon Ballot Measure 114. Now, for those of you who geeked out on the channel back in the day when we were covering Ballot Measure 114, you will recall that this wonderful piece of revolutionary legislation was going to require every Oregon resident to go out and get a license to exercise a constitutional right, but in order to get the license, they would have to demonstrate their proficiency in exercising that right. And that was just the beginning of the problems. It also extended Oregon's statutory waiting periods, and it provided a high capacity, or what we like to call standard capacity, magazine ban. That law was ever so slightly passed into legislation by the Oregon voters on the slimmest of margins, and almost immediately the lawsuits dropped. Now, the state of Oregon, which all along had said that they were totally prepared for this licensing regime and were ready to defend this law, was not prepared for a judge with common sense and an understanding of constitutional principles down in Harney County. And this law has essentially remained enjoined. There is not one aspect of it that has gone into effect anywhere in the state of Oregon because of Judge Ratio in Harney County. Now, the state of Oregon, as I mentioned earlier, not once but twice, stampeded down to the state capitol to get in front of the state Supreme Court to say, hey, you need to stop this. And the Oregon State Supreme Court on both occasions declined that invitation. That should tell you something. And what it should tell us is that Oregon Ballot Measure 114 is an absolute abomination of constitutional rights. It's one of the worst pieces of legislation ever written, and therefore should be chucked into the wastebasket. However, what we're talking about today, Oregon, is not Ballot Measure 114. Rather, no, it's Senate Bill 348. So what exactly does Senate Bill 348 do? Well, what it basically does is it takes the absolutely atrocious, horrible piece of legislation passed through the ballot initiative process, the ballot measure process in Oregon, cuts and pastes it onto a bill that was then sponsored by an Oregon State legislator out of the Senate, and then intends on passing the exact same garbage legislation through an enactment of the legislature versus through the ballot measure process. So what it really is, it's the exact same disaster with a different packaging on it. Don't believe me? Well, why don't you just read the staff summary of this proposed piece of legislation? Because what does this proposed piece of legislation purport to do? Well, according to the staff summary, it reads as follows. It replaces the bill, provides that a permit to purchase a firearm is not required until July 1st, 2024, provides that a permit to purchase a .22 caliber rimfire ammunition, muzzleloader rifle, or shotgun with a pump, brake, lever, revolving action, and other firearms listed in ORS 166.250 is not required until July 1st, 2026. So yeah, this Senate bill says rather than immediately strip you of your constitutional rights, we're actually going to set out some future dates where your rights will be stripped from you. That's where we will actually require you to get a hall pass, a permission slip, before you get to exercise a constitutional right. But wait, there's more, because the bill analysis also states this bill does the following. raises the age from 18 to 21 to apply for a permit to purchase, provides that a person may not apply for a permit if within the previous 4 years they have been convicted or found guilty, except for insanity, of a misdemeanor involving violence as defined in ORS 166.470. And this is important. You guys are going to need to geek out on that in Oregon. How does Oregon define violence in there? Because what you could be doing now is you could be stripping people their constitutional rights for engaging in violent criminal conduct, which is not normally the type that actually forfeits Second Amendment rights. That is, there's a huge difference between an assault and an assault domestic violence. That is important. Interesting also to note that if you're found guilty of it, that's going to be a problem. But if you're found not guilty by reason of sanity, well, hey, that's no problem at all. There's more to this bill, though, including provides that a permit agent may deny an applicant for a permit if they have reasonable grounds to conclude that the applicant has been or is reasonably likely to be a danger to self or others or the community at large, and that this investigation must be based on objective facts and information known by or records available to the permit agent that establish a pattern of behavior involving unlawful violence or threats of unlawful violence sufficient to clearly establish that the applicant has been or is reasonably likely to be a danger to self or others. Which is a long, fancy way of saying gives the licensing regime, the licensing agency, unfettered discretion to deny applications for arbitrary and capricious reasons. Oh, but you see, Oregon, there's even a little bit more in the bill that probably people aren't talking about. But after doing some digging around, it appears that the fees, that is the licensing fees, that is the cost that you would need to pay in order to exercise what is supposed to be an inalienable right, were originally $65. But now it's going to be raised to $150 under Senate Bill 348. Oh, and the renewals for the permits that were also going to be originally $65, yeah, that price now is going to be raised to $110 per renewal. But ultimately, Oregon, what this is this is an end around to the obvious constitutional and other statutory challenges occurring on Ballot Measure 114. Your state legislature knows that this is an absolutely horrible piece of legislation which is not going to survive constitutional scrutiny. Rather than accept defeat, what they are going to instead do is pass Senate Bill 348 and subject you to a whole new level of unconstitutional laws, which will then require a whole new level of judicial review and thus buy them more and more time to inflict their misery upon the lawful and responsible citizens of the state of Oregon. And even though there was a hearing last week, and according to statistics, it was about 19-1 signing in opposition to this bill, make no doubt about it, because we're seeing this in my home state of Washington as well as several other states, that this is all about politics and not about preserving rights, and certainly not about saving lives. Oregon, you need to be very careful about Senate Bill 348. Basically what it is it is a wolf in sheep's clothing. This is Oregon Ballot Measure 114, just wrapped up with a different set of wrapping paper on it. Listen, you may have more questions about this bill or anything else related to what's left of our Second Amendment rights. If you do, you should know how to get a hold of Washington gun law by now. But if you don't, hey, all of that information is right there in the description box. In the meantime, I want all of you to remember that part of being the lawful and responsible gun owner, like we talk about all the time here at Washington Gun Law, is to know what the law is in every situation and how it applies to you in any instance that you may find yourself. Until next time, thanks for watching and stay safe.